IP, IP,
IP,
IP, IP,
IP,
IP, IP. Welcome to IP series, home to all things IP related, where I give you the stories, tips, and implications to business and creative decision concerning your intangible assets with real life case study. I am your host, Rita Anri Chinda. Subscribe and turn on your notification so you don't miss an episode. Cheers, guys. So, if you're yet to listen to the last episode where I discussed the myth about intellectual property, please check it out, IP fans. I would really appreciate to see my streaming numbers going up. But today's episode, 107, is kind of long overdue for me, and it was inspired by a post by my chungi at Faith Obafemi, the blockchain slash digital queen. She tagged me on this case last month, and it took me a long time to do the carousel. And while I was doing my research, I was like, why didn't I just do a podcast version? And here I am today, about to begin the recording of the podcast version. So basically, this case features translation rights and intellectual property rights for museums, and this case is between Yilin Wang against the British Museum. Now, as a copyright owner, you are entitled to what is considered to be a bundle of exclusive rights, such as the right to translate, to adapt your work, to distribute, to publish, to reproduce, to, do anything that will bring you commercial value. So I'm going to highlight what this right of translation is. I'm also going to do in the next episode, I'm talking about right to reproduce, right to publish, and right to distribute, because of another case which will be published next week. So look out for that. But today's case, really caught my attention because it's not something that we really take into consideration here. And maybe because the museums in Nigeria are hardly being visited. I mean, we have one in Port Harcourt. I'm based in Rivers State, Port Harcourt. I've never been to that one, but I've been to, did I say one? Yeah, I've been to one in Lagos. Yeah. And I have a client that also manages museums. So, I also have to get my tentacles in basically everything intellectual property. But why this interested me was because while following the thread, a lot of conversations were revolving around colonialism, disrespect to culture, especially coming from the British Museum. You know that the British colonized a lot of countries, and Nigeria happens to be one. But then, let me not digress. For today's conversation, like I stated, I would dissect the bundle of exclusive rights, which is the right to translate. And you know that copyright owner enjoys this by starting to make money from it. So, what is the summary of this whole case that Faith tagged me to? And I was like, I'm waiting for your kind attention. So, the tweet I was tagged to read, so this is at Yilin Writer. So it stated, hey, at British Museum, it's come to my attention that your exhibit, China's Hidden Century, uses my translation of Qiu Jin's poetry, but you never contacted me for permission. Please note, this is a copyright infringement. How are you going to fix this? Hashtag name the translator, hashtag pay the translator, which I found inside. So keywords here for me are never contacted for my permission. This is a copyright infringement, uses my translation. What does that tell you? That she's asserting that she is the owner of the translation used for the British China's Hidden Century exhibition. And when Faith tagged me to this, I was like, interesting. Then I waited a few days and I saw that the British Museum museum offered to pay Yilin for using her translation after they had been called out on social media for copyright infringement. So the newspaper publication says British Museum offers to pay translator after plagiarism. It's not plagiarism, it's infringement basically. And I follow the conversations, and I think there was this user that actually volunteered to go to the museum to check out the translation that she stated they had exhibited. But unfortunately, by the time the person got there, bits of her translation had been removed. I guess because of the attention that that post got. So I did a bit of research on intellectual property rights for museums, what they need to know when they want to do exhibition. So I came up with a couple of questions. First is issues museum face when curating exhibition. Second is the right of translator, which I feel should have been the first one anyway. How to comply with copyright law as a museum owner. Intellectual property management for museums. How museums can comply with intellectual property provision. And I must add, I know there was this publication I did around tourism development, cultural heritage. I'm going to include that as well. So if you hear me delving into cultural heritage conversation, please bear with me. Let's get cracking. First is copyright as a type of intellectual property grants the IP owner some sort of interest as a result of his human intellect output that was created. And now for a translator, they are both considered to be a creator and an author, irrespective of the quality of the work that they created. They also have the right to control its future use and grant other people the right to use their work in question. Now, when you now talk about digitization of copyrighted works and making it available online, you will now consider exclusive rights such as the right to reproduce or communicate to the public, each of which will usually require that you get the consent, permission, authorization from the copyright owner or holder. In other words, if the British Museum owns the physical copy, they cannot claim ownership or copyright to be able to copy it or display the translation in question digitally. They must obtain authorization either by means of directly getting the consent from Yilin, or individual negotiation with the rights holders, or through a framework agreement, within the territory, within the UK. Now, under the Nigerian Copyright Act, Section 108 defines literary works to include poetical works, compilation, including compilation of data stored or embedded in a computer or any medium, while works include translations, new versions or arrangement of pre-existing work that present an original character. Now, exclusive rights, as it is also an expression of creative activity, such as the right to translate a work. You can find the provisions under Section 9, Paragraph D, Paragraph E, and then you can also, okay, I'm going to talk about that later. But then what we need to know when we're talking about translators is that if you work in the translation industry, or if you own or manage a museum, you must understand how intellectual property works. Also understand how ownership interest is created out of human intellect, and how you can eventually get to control the work in question. Without that, what you would be alleged to be committing is an infringement, not plagiarism at this point. So, who is a literary translator? Now, this is someone that translates written works from one language to another. Now, a literary translator may work on novels, poems, essays, short stories, or any other form of literature. They also sometimes face challenges such as capturing the style, tone, and voice of the original author while trying to preserve the cultural and historical context of the text, and also finding equivalent expressions and idioms in the target language. They also need And this is important. They need to have a good knowledge of both languages as well as the literary transition and conventions of each. They may work independently or for publishers or agencies or organizations such as the British Museum. They may also be required to collaborate with other translators or editors to ensure that the quality and accuracy of their translation is on point. And I think this is where Yiling's disappointment with the British Museum came in. I mean, for someone like the British Museum, not, taking into consideration their colonial history, they should have reached out to her to collaborate and make sure that they communicated or published or distributed her interpretation or her translation of Qiu Jin's poetry. Literary translation is also the act of rendering a written work from one language to another. And some of the challenges that they face, like I earlier mentioned, I talked about cultural differences. The translator may have to deal with the nuances of different cultures, such as idioms, metaphors, humor, references, and values. They also need to find a way to convey these aspects without losing or distorting them in the target language. Creative choice. You know that as a creative, your work must be in an original form, as it's being expressed. Doesn't matter the quality, but you have to make decisions about how to translate, interpret, and adapt the text to suit the expectation and preference of the target audience. Because this was a Chinese translation, she needed to compensate the Chinese audience that will be reading her work. She also, Yilin would have to balance fidelity, freedom, accuracy, and creativity in all of this, so that there's no ambiguity, there's no irony, there's no figurative language in the text, so no one gets offended. You're not restraining her creative freedom, but you're also giving her the opportunity to interpret it without being insultive or condescending. And there's also ethical issues that translators would face, and that is respecting the author's intention and integrity of the text. They also need to avoid plagiarism, which is one of the things that the British Museum was accused of. They also need to avoid censorship, manipulation, or distortion of the text. So at some point, the British had to take a certain part of Yiling's poem, and because her tweets raised a lot of eyebrows in the media, and especially within the digital space, that she had followers wanting to help her verify that the British Museum actually published the work, or they had taken it down from their exhibition. They also sometimes face legal and ethical challenges related to copyright and intellectual property. And then this is where Anwuri comes in now, the IP aspect of my research. So I already began by introducing what copyright is to you, but let's delve into one of the main challenges that literary translators face when trying to obtain permission from the author or the publisher of the original work to translate it. Um, Sometimes it could be very complex or costly, um, especially if the work is not in the public domain or if there are multiple rights holders involved. The translators may also need to negotiate the terms of the contract, such as royalties, deadlines, editorial control. They also need to respect the moral rights of the author of the original work. Now, moral rights was briefly talked about in the old Copyright Act, but under the new Copyright Act, the drafters of the law took their time to make extensive provision as to what moral right entails. And that's something that I also think most copyright owners do not really pay so much attention to. So I'm going to use this case to talk about moral right under section 14. You can also read the section to understand, or maybe hold on, let me open it on my phone and read it for you guys. So section 14 says, subject to part 2 of this act, The author of the work in which copyright subsists has the right to claim authorship of his work, which Yilin did by putting out that publication. In particular, that his authorship be indicated in connection with any of the acts referred to in section 9 to 10, that is for literary work, artistic work, musical works, and when the work is incidentally or accidentally included in a broadcast when reporting current events. This was not a broadcast. Um, Yilin has the right to object and to seek relief in connection with any distortion, mutilation, or any modification of and any other derogative action in relation to her work where such action would be or is prejudicial to her honor or reputation. She also has the right to object to the work being falsely attributed to her as the author. Now, sub 3 says these rights referred to in subsection 1 shall not be transmissible during the lifetime of the author. This wasn't clearly provided for in the old Copyright Act. So now you cannot transfer someone's moral rights. Yilin cannot transfer her moral right if she was a Nigerian, but she's not Nigerian, she's Chinese. But Yilin can transfer her moral rights during her lifetime, and if the author of the work dies, it is transferred by way of a will or operation of the law, and finally it shall last for the duration of the copyright of the work. So for literary work or poems such as Yilin translation of Jin Jin's, oh god, apologies to my Chinese listeners, I am so sorry. I did look up the Google pronunciation, but I don't know why I'm messing it up now, but I'm really really sorry. But the poem translation will last for as long as it is supposed to last. So the lifetime of the author plus 70 years afterwards. Now, it was also interesting to know that after I did a good research, just to confirm the position of moral rights under the Chinese copyright law, it states that the period of protection for the moral rights of publication and economic right or the right to exploit the work for economic gain is generally 50 years from the date of creation or publication, or in the case of individual, the lifetime of the author plus 50 years. Isn't that wonderful? I mean, Nigeria gives you 70 years and Chinese gives you 50. So I don't know if I should do, because it's the British Museum that published this translation. I think we'll also look at the UK provision for moral rights. So interestingly, under the UK Copyright Act is also 70 years. So going or looking through the UK website, it says right granted by copyright. If you own the copyright in a work, you have the exclusive right over certain use of the work. These rights falls into two categories: economic rights and moral rights. Now, moral rights, as provided for here, talks about so it says works often mean more than just the economic value they can generate from their exploitation. They can be very special to the person who creates them, just as the translation Yilin Wang did of Jane Shen's poem is very special to her. She has also invested a lot in the work emotionally and intellectually, and as a result, copyright works need to be protected in ways that are different to traditional forms of property. Moral right protects those non-economic interests and are only available for literary, dramatic, musical, and artistic work and film, as well as some performances. Now, I'm glad that they talked about performances because under the new Copyright Act 2022 for Nigeria, especially if you're looking at section 66, it makes provision for moral right of performers. So all of you that keep saying we don't have the law, go and read the Copyright Act. Now they play. But it said goes further to say, unlike economic right, moral right cannot be sold or otherwise transferred. However, the right holder can choose to waive these rights. Now, under the UK, there are four moral rights recognized. So, the right to attribution, the right to object to derogative treatment of a work, the right to object to false attribution, the right to privacy of certain photographs and film. I would say that under our own act, it was just merged into um, paragraph A, B, and subsection 2 of section 14. So yeah. Now another challenge you need to take note of is dealing with plagiarism and piracy. Now plagiarism is the act of passing off someone else's work as your own without giving proper credit or acknowledgement. So I guess this is where um you know the newspaper publication got their idea from, and they're like, okay, this paper actually they've plagiarized Yiling's translation of the Jing Chain's poem, and they're like, we don't have any of that. Um, okay. Whereas when you're talking about um piracy, you'll be referring to an unauthorized reproduction or distribution of someone else's work without paying for it or obtaining permission. And you find out that most literary translators face plagiarism or piracy from other translators who copy their work or from publishers who distribute their work without their consent, or organizations such as British Museum who publish their work during an exhibition without their consent, thereby damaging their reputation and also restricting them from any money in form of royalties um, after their rights have been violated. Plagiarism is not a criminal offense, but is an ethical issue. And this is, like I stated, someone using your work without proper attribution or acknowledgement. It can also occur when the original work is not protected by copyright. Plagiarism sometimes is linked to academic or professional um, consequence, whereas for copyright infringement, we're looking at a legal violation that can be pursued either by a civil or criminal suit, and this will occur where your bundle of exclusive rights have been exploited or commercialized without your consent. It also hinders you from um, any royalties, um, prevents the exclusive use of your work for a set period of time, and that's because a third party has breached your copyright. Now, types of offenses are divided into two. You have primary and secondary of infringement. Primary infringement will involve direct offenses such as copying, distributing, performing, or displaying a protected work without permission. So, you will say that the British Museum has committed a primary infringement by publishing or displaying Yilin Wang's translation. Secondary infringement occurs when someone facilitates another person or group infringing on a copyright, such as importing, possessing, or dealing with infringing copies. I hope that you now understand the difference between copyright infringement, plagiarism, and piracy. Now you can now ask me, what are the legal requirements, legal remedies for copyright infringement in Nigeria, since they are both civil and criminal. The civil remedies will include injunctions, damages, accounts of profit, delivery up, and conversion, while the criminal liabilities include fine, imprisonment, or both. And the Nigerian Copyright Commission is the agency that addresses issues of copyright in Nigeria. I think I've said that a couple of times um, in my publications or most of my IP series content. Yeah, I have. How can one prevent infringement? One, don't always assume that a work is protected by copyright unless it's expressly or explicitly stated. Always obtain consent permission authorization, written consent permission authorization. I know currently under our act, it makes provisions that when it comes to licenses and assignment, I'm trying to get to it, apologies. When it comes to licenses and assignments, it, it has to be in writing. An assignment or a license under Section 30 of the Nigerian Copyright Act suggests that it shall be deemed to be a movable property and shall be transferable by way of an assignment or testimony, disposition or operation of law. That is for um, the copyright itself. Now, it also goes to state that where a person, in the absence of an agreement to the contrary, creates a work for service, blah blah blah, it will belong to, the department or agency or government ministry or the prescribed international agency. But this is not the case. No written agreement. Um, you know, no written agreement here. So I was going to read section 30 sub 2, which states that, okay, let's do sub 3. It says an assignment of copyright or an exclusive license to do an act is doing which is controlled by copyright shall have no effect unless it's in writing. So when you're talking about licensing, it always has to be in writing. Now, for a non-exclusive license to do an act which is controlled by copyright, such as the right to publish, distribute, etc., so it may be in writing, oral, or might be inferred by conduct of the owner of the copyright. So all of this needs to be taken into consideration when you're having those conversation. Don't get swayed by the money that they're calling. Also create original works instead of copying existing work. Use public domain or Creative Commons license work where possible. Provide proper attribution for any work you use, which is something that the British Museum also failed to do. Monitor your work to ensure that they are not being infringed upon by others, and if you have not familiarized yourself with the takedown notice under the Nigerian Copyright Act or maybe the Digital Millennial Copyright Act as it applies to online activities, please do so. Make sure that you do the needful and remember that copyright infringement can result in serious legal consequences. So take all of these tips that I have mentioned. I was going to say measured. Oh my god. I've mentioned on this episode. Now, for museum, we know that it's not easy curating an exhibition. So, what are those things or challenging tasks that requires careful planning, research, and collaboration that museums may face when curating exhibitions? You need to balance the need and expectation of different stakeholders, such as artists, funders, visitors, and communities. Dealing with ethical or legal or social issues that may arise from the exhibition context, such as cultural sensitivity, intellectual property rights, and environmental impact. They also need to evaluate the success and impact of their exhibition on the museum's mission, visions, and goals. They need to ensure accuracy, relevance, and accessibility of the information and interpretation presented during the exhibitions. Now, these issues require the museum to adopt a very strategic and creative approach in curating exhibitions that engage diverse audiences, showcase diverse perspective, and fosters dialogue and learning. Now, what are the rights that a literary translator enjoys, or a translator basically enjoys? First, the right to access the original text as well as any pertinent data or files that will aid in producing a top-notch translation. The right to refuse to translate texts that are illegal, offensive, or contrary to their ethical principles or professional standard. the right to be recognized as the author of their work and to have their name mentioned in the translated text. They also have the right to seek edits or revision of their work if they discover mistake or inconsistency after the translation has been delivered. And finally, the freedom to decide on their conditions of employment with a customer or publication and to be paid fairly for their job. So one of the provisions of the Copyright Act that I would like to draw our attention to is Section 25, and that is the special provisions for archives, libraries, museums, and galleries. So what it provides for here says, notwithstanding Section 9 to 13, which talks about literary and artistic work and all the bundle of exclusive rights that they enjoy, um, archives, libraries, museum, gallery may for non-commercial purpose, emphasis on non-commercial purposes, make and distribute copies of the work protected under the Act as part of their ordinary activities, make copies of the work in their collection for the purpose of backup and preservation, make or procure a copy of any missing part of a work in its collection from another institution, make or procure a copy of any work that is or should be available in its collection in any chosen format where the work cannot reasonably be acquired in that format through general trade or from the publisher, or make or procure a copy of any work where the permission of the owner of the original cannot be obtained after reasonable effort, or where the work is not available by general trade or from the publisher. And then subsection 2 states a copy of the work made in whatever format in accordance with the non-commercial purpose section may be lent to users or used for private study or research on the premises of the institution with or without the means of technical equipment. How fascinating is our new Copyright Act? Amazing, right? Yeah. So another one that I thought was very important for our case study is a compulsory license required to produce and publish translation. Now, Section 31 provides that any qualified person may, for the purpose of teaching, so if you want to teach, you're on research or it's for scholarship, you can apply to the Nigerian Copyright Commission for a license to produce and publish a translation of a literary work that has been published in printed or analog forms of reproduction. Now, the application shall state the purpose, the proposed retail price of the copy of the translation of the work, and the applicant under this section shall pay such fees as may be prescribed by the Copyright Commission. Now, where an application is made to the Commission, the Commission may grant. So you're going to go into a non-exclusive license with the Copyright Commission to publish a translation of the work in the language mentioned in your application. Now, you will pay the owner of the copyright work royalties in respect of the copies of the translation of the work produced, calculated at such rate as determined by the Copyright Commission, and the circumstances where each case determined and is consistent with the standard of licenses freely negotiated between persons in Nigeria and owners or translators in their country. Now, the license shall not extend to, so you cannot export the copy of this translation outside the shores of Nigeria, and every copy of such translation shall contain a notice in the language of the translation that the copy is available for distribution only in Nigeria. So you shall not apply to export by government or any of its agency of copies of such translation in a language other than English to the country if such copies are sent to citizens of Nigeria residing outside Nigeria, or to any association of such citizens outside Nigeria, or meant to be used for purpose of teaching, scholarship, or research, and the government of the country to which the copies are exported to agree to receive or distribute the copy. Now, a license shall not be granted by the Commission until the expiration of 1 year from the date of first publication of the work, where the application for a license for translation into any language spoken in Nigeria other than English. 3 years after the date of first publication of the work, where the application is for a license for translation into English. A license will not also be granted to you by the commission except the commission is satisfied that no translation of the work into the language in question has been published in printed or analog forms of reproduction. The applicant has proved to the satisfaction of the commission that his request that he had requested and had been denied permission by the owner of the copyrighted work to produce and publish such translation, or that he was, after due diligence on his part, unable to find the owner. So you see that the commission has made things a bit easier. So you can't say ignorance is an excuse. Have you really shown the commission that, oh, I don't try find this person, he had, I never see the person, you know, or I've gone to meet the person does not want to give me consent, help me, commission. The commission will now step in, and that's one of the roles of the copyright commission as provided under the new act. Now, whereby you've also done your due diligence and you were unable to find a copyright owner, you have sent request for permission to the publisher whose name appears on the work not less than 2 months before applying. The commission will also step in. And if at the time when you submitted your application, um, you informed any national or international information center designated for this purpose by the government of the country in which the publisher the work be translated is believed to have had its principal place of business, the commission will step in. The commission is satisfied that you are competent to produce and publish a correct translation of the work, and you possess the means to pay the owner of the copyright the royalties required to be paid in. So you see how the Copyright Act is encouraging people to pay royalties to appreciate the owners of the work. Now, if within a period of, say, um 6 months, so a period of 6 months in the case of an application for license for translation into English, or 9 months in the case of an application to translate into any other language spoken in Nigeria, say Hausa, Yoruba, Ikwereti. Yeah, I had to mention them. Anyways, or where your request are made under subsection 1C for a period of 6 months have elapsed from the date of sending the request and the translation of the work in the language mentioned in the application, and has not been published by the owner of the copyright in the work or any person authorized by him within a period of 9 months, the commission will step in. The name of the author and title of the particular edition of the work proposed to be translated are printed on all copies of the translation. Also, where the work is composed mainly of illustration, the provision of subsection 6 of this act are complied with. The author has not withdrawn copies of the work from circulation, and there's an opportunity of being heard by the commission wherever practicable to the owner of the copyright. Now, the Copyright Commission may also withdraw your non-exclusive license where the circumstance led to its grant to be seized. I don't know if that makes sense, but if it doesn't, send me an email to ipseriesinfo@gmail.com. So you know when I made alluded to section 6. Now section 6 talks about copyright by reference to a country of origin, and it goes to say copyright shall be conferred by this section on a work which is a literary, musical, or artistic work, or an audiovisual that is first produced in Nigeria, sound recording made in Nigeria, and has not been the subject of any copyright conferred under section 2. Section 2 makes provisions for the criteria. So first is it lists the eligible works and talks about the criteria of a work being eligible for copyright, which is effort has been expanded, is in a fixed or tangible format. It doesn't matter the quality of the work, in with or without the aid of a machine, you know. And it goes further to state broadcast transmitted from Nigeria or by a broadcasting organization that has its headquarters situated in Nigeria. So we're going to make reference to section 18, which provides that copyright shall commence the moment a work is created or made, which in this instance, the moment the Yilin Wang's translation was made, he enjoys copyright protection. And if there's no agreement between her and any other person, she is first of all going to be recognized as the author in the absence of an agreement. Then I had alluded to how I was going to talk a bit about cultural heritage, um, what we can do to preserve it. Presently in Nigeria, it's only the Lagos state that has a law for cultural heritage and preservation. And we know that cultural heritage will include things like museum sites, um, monuments, anthropological, scientific significance, and they can be tangible or intangible. Right now, I think our focus is going to be more on the intangible assets that we have in form of copyright and related rights, trademark for unique signs, slogan symbols, mm, design right protection for combination of lines and colors. And we know that when we're talking about copyright, we made emphasis on the two types of rights, economic right and moral right, and the exclusive rights, which led us to have conversation on translation rights as well. The importance of preserving cultural heritage is preserve the identity of the community. And I think if you look at it from that angle, you see that Yilin is trying to preserve the identity or the creative expression of her translation of Qiu Jin's poem that she translated. It also gives her a sense of belonging. She gets communal support and also a source of economic development and tourism. Benefit of cultural heritage tourism is it creates jobs, promotes active preservation and protection of important resources, creates awareness of unique things about the community without being disrespectful. Um, so in wrapping up, we will be wrapping up in a bit. But I hope that with these few points of mine, I'll be able to make sense on how rights of translation really operates and what we can do to assist translators within our circle. How do you support a translator? You recognize and attribute their work, provide them with professional development and support, and pay them their royalties ASAP. So, in conclusion, if someone exercises their right, such as Yinling, who happens to be the corporate owner of the translation, and they do that without her consent, they are invariably infringing on her work, and she has the right to actually sue for copyright infringement. So how can museums now comply with intellectual property provisions and avoid legal disputes? First, they must conduct due diligence to verify who owns the intellectual property right for the work they intend to use or display or even exhibit. Also get the current status as to ownership and if there's any restriction or exception to their use, such as fair use or fair dealing in Nigeria, or public domain, they should add additionally confirm that they must obtain permission, written permission, respect moral right, and also educate their staffs and visitors about rules and guidelines that govern how they may use their artifacts on display or being exhibited, as well as train their employees on how to handle intellectual property issues. Additionally, they must clearly state any limitation or prohibition pertaining to photographing, recording, or reproduction of protected work. So finally, whether you work in the translation industry or in a museum, you need to establish and enforce an IP policy and outline the museum goals and objective and guiding principles in relation to intellectual property, as well as providing precise guidelines and standards for handling intellectual property issues such as the one that British Museum is experiencing with Yilin Wang. Um, Institutions could vary from acquisition to preservation to exhibition, publication, education, research, collaboration, and commercialization. Well, we've come to the end of today's episode of IP series. We've learned a lot about translation rights and intellectual property rights that museums get to experience, what IP due diligence you need to carry out when curating exhibitions, and how to support a literary writer or translator, the rights that they enjoy, what are the challenges that literary translators face, what the special provision for museums under the Nigerian Copyright Act 2022, how moral right play into all of this conversation, a little bit of cultural heritage with regards to the Tafawa Balewa Square being pulled down by a private company. I hope you enjoyed this episode and found it informative and inspiring. I would like to thank my IP friends for listening and tuning in and always supporting IP Series podcast and all IP Series content. And if you have any questions, comments, or feedback, please feel free to contact me via ipseriesInfo@gmail.com or follow any of our social media handles at ipseries_with_Esmeralda ASQ or at ipseries1 or at, I was going to call my my personal handle, but I just totally blanked out. But yeah, we definitely love to hear from you. Please don't forget to subscribe to our podcast. Leave us a rating or review on your favorite platform. It really helps us grow and reach more people. And in our next episode, we'll be talking about another exciting topic related to creativity and innovation in Nigeria. So stay tuned. And until then, keep creating and innovating. This is Rita Anrichinda signing off from IP Series. Do have a great day and see you in the next episode, guys. Cheers.